reluctantly took it out and is trying to bring it back. And so I'm just pleading to the legislators to pay attention to the evidence. This is not about transgender rights. This is well established in Colorado law. Instead, it suggests that the only approach to minors with gender dysphoria or gender incongruence is affirmation. And this is before they can be reliably established as transgender. We know that about 80% of, it's already over? Okay. 80% desist, and my main point is that the evidence to support an affirmation approach is just not in the medical literature. The CAS review and others have pointed that out, and I think things will change. I just implore the Colorado Assembly not to get ahead of the evidence in the future. Thank you.
Thank you. Please hold for questions after further witnesses. Mr. Miller, please go ahead.
Hello, my name is Joel Miller. I live in Colorado Springs. I'm a staff attorney for the Pacific Justice Institute, and I'm here to testify against 2618. This bill is unconstitutional. I understand that the sponsor is asked to remove Section 2, but she has also promised to have it come back, and we haven't seen that it's actually been removed at this point. So I testify mostly in the provisions under Section 2 under constitutional problems. The first is the infringements on parental rights due to the due process clause of the 14th Amendment. There are certain fundamental liberties that the 14th Amendment addressed after the Civil War that said these are fundamental things, whether or not they're enumerated in the Constitution. And the care, custody, and control of children has been repeatedly emphasized by the Supreme Court as one of those fundamental liberties. And by putting that in the bill where a parent's custody and decision-making over their child could be impacted by whether or not they agree with the orthodoxy is taking away from that fundamental liberty. And it will have constitutional challenges. Colorado has already been rebuked multiple times, and this will be one more way for the state of Colorado to be embarrassed by the Supreme Court and a rebuke. Besides the 14th Amendment, it also violates the First Amendment, compelling speech. If you're a parent, you are compelled to either agree with the orthodoxy or you're compelled to say that you do agree with it. And if you do, then maybe you could have custody of your children. If you don't, then now you're being told you might not have custody of your child. It also violates the free exercise clause of the First Amendment. It is not neutral on its face. Even if we're told that it's neutral on their face, it is not. And it requires strict scrutiny, which it would fail under judicial testing for strict scrutiny. This bill is unconstitutional. If it were to pass, if it comes back and gets passed again, it will be seen at the Supreme Court. It will get struck down. It will embarrass Colorado. It is a fundamental attack on constitutional rights. Please reject this bill or anything.
Thank you, sir. Ms. Hanford, please go ahead.
Good afternoon. My name is Laura Hanford. I'm a senior policy analyst with the Heritage Foundation, and I'm testifying today in my personal capacity. And while the amendment strikes an egregious provision of the bill, it's clear that the bill was constructed as a means for the state to lock in an ideologically driven identity for a child by removing a parent who might stand in the way and then helping that child legally disappear from his or her own parent. The initial bill compounded the trauma of divorce by injecting the false premise into custody disputes that encouraging a child to reject his or her sex is in the child's best interest. This is manifestly untrue, as demonstrated by every systematic review of evidence on pediatric sex-rejecting interventions. There is no scientific evidence or marker for gender identity, but the harms include sterilization, cognitive impairment, new forms of cancer, loss of sexual function, and bone degradation. And we know that socially transitioning a child locks in subsequent medicalization, whereas a child who is provided supportive care but not medicalized embraces his or her biology in almost all cases once puberty passes. Colorado courts already have a terrible track record of adjudicating from the upside-down standard that it is in a child's best interest to be protected from a parent who has loved and cared for the child for a lifetime, but simply refuses to lock in future harm. The continuing problem with this bill is that it compounds that harm by effectively causing the child's disappearance from one or both parents. Nowhere in this bill is there a reference to the parent being notified of the child's name change. And in a situation where a court has unjustly removed the child or awarded custody to the parent who will medicalize, this bill could be used to simply make the child disappear. Notwithstanding the sponsor's assurances, the intent here is clear. There is nothing redeemable about this bill, and unless what remains explicitly names parents, their rights to access, care for, and know what is happening to their own child are not protected. Thank you.
All right, thank you. Madison Rolls, please go ahead.
Can you hear me?
Yes, please continue.
Okay. I am Madison Rolls, and I'm here representing myself. Chair and members of the committee, I urge you to vote no on Senate Bill 18. This bill presents a serious overreach of government authority into the family. The state's role is to protect public safety, uphold the law, and provide essential services, not to insert itself into deeply personal parenting decisions. Despite popular opinion, you cannot change your gender. None of you actually believe this, but since it's trendy to disregard facts and to avoid offending people, you will go along with this lie. One day when we look back, we'll always remember those who were willing to do the right thing, were not willing to do the right thing to remain popular. If you are more concerned with public perception than doing what is right, you are demonstrating that your leadership is rooted in fear rather than principle. As voters, we take note of that. I expect the individuals who represent me to stand for the truth, regardless of the personal or political cost. This legislation sets a dangerous precedent, and that kind of power should be reserved for clear cases of harm, not differences in belief or approach. Public safety should be your number one concern, and the numbers prove that so-called transgenders who have mutilated their own bodies have no problem mutilating other people's bodies as well. The trans community is the primary demographic of those committing mass shootings. Encouraging parents to go along with this deranged lunacy is suicidal empathy and ultimately not good for our state. I stood opposed to the Kelly Loving Act last year, and I stand opposed to this bill for the same reasons. And if anything, this last year has given me more reason and confidence to stand opposed to this bill. I'm thankful that you took Section 2 out, but I know, like others have said, that you are trying to sneak other things in and trying to test the waters. So I'm here to just tell you that we are watching, and Colorado does not want this. Please vote no. Thank you.
All right, Ms. Mosley, please go ahead.
Hello, chair members of the committee. My name is Katie Mosley, and I am here as an individual. I am in opposition to Senate Bill 2618, and I would like to respectfully request that Representative Meg Frolick recuse herself from sponsorship and voting on this matter due to conflict of interest. Given the representative's sponsorship of Caden's Law passed in May 25th, 2023, and the direct overlap of the subject matter affecting custody determinations and allegations of abuse, this is necessary. This bill is an insult to DV survivors and every child who has been sexually groomed, molested, exploited, trafficked, and raped by an adult predator, especially in cases of incest. This is not dignity, it's deception. This is exactly what coercive controllers do. Abusers have no reservations about coercing and controlling children. It's the literal definition of a child groomer. Suppressing name changes cuts off the safe parent entirely from pediatricians, therapists, schools, and even hospitals, and they're already doing this, including passports. This incentivizes abusers to frame the safe parent for custody who wants to block and hide physical and sexual abuse. Financial abuse is already used against stay-at-home mothers who often are the ones who report that abuse. Secrecy is allowed 420 days of no contact with my daughters who are pre-puberty. Non-disclosure and suicidal ideation hospitalization of my daughter already occurred at Children's Hospital. They tried to block me from seeing it using this method of removing me from my chart and naming someone else as the legal and biological parent. It's fraud, and law enforcement refused to file a report. This gives them an official tool to carry out what they're already doing. An abuser loves to defile a name, and these are psychopathic people. They have no qualms about lying to children, making them question the reality. It's what they already did to the protective parent. Play therapists are alone in the room with children, misusing the DSM, diagnosing anxiety and depression instead of child sexual abuse and psychological abuse. And they are attracting groomers to this field who are happy to do so. This bill is a
And
Trojan.
thank you for your testimony. We've
Thank
run
you.
past
You
time.
can visit me while I self-litigate my case in court.
All right. Members, are there questions of our witnesses? All right, we're seeing no questions. Thank you for testifying. Okay, I'm going to continue calling names of folks who signed up opposed. Do we have